Hello everyone, welcome. Today we will be looking at a very important and interesting area in the law on probate. Today we will be looking at the resealing of a grant of representation. What exactly is the resealing of a grant of representation? Now, the resealing of a grant of representation is the procedure by which a grant is basically obtained in a Commonwealth country, and in order for it to be effective in the home territory, it actually has to come to the home territory for that grant of representation to be sealed. Now, the relevant legislation that deals with the resealing of grant is the Probates Resealing Act. The Probate Resealing Act under sections 3 to 6 details what is the procedure when a person goes ahead to reseal a grant in a home territory. The first thing is that the law states that the copy will have to be deposited in the Supreme Court for it to be sealed with the seal of the court. The second thing is that the person or the applicant has to pay the relevant estate duty in order for that resealing to take place. Now, the Act also states that if there is a creditor and the creditor calls on the estate, then what will have to happen is that there will have to be a security for that debt prior to the court resealing the grant. The particular section of the Act also states that the place where the deceased was domiciled also have to be included in the relevant application. The fourth thing that you will recognize that is contained under the legislation is that a duplicate grant of representation is just as effective as if the original was submitted to the court. Now, there are a number of documents that you will need to submit in order for you to satisfy the court that you intend to reseal this grant in Jamaica. You must have a notice of application to reseal the grant, and that is the first document that you will have. You will also need to have the oath of executor or the oath of administrator. The person who is usually responsible to make the application is an executor or an administrator or the attorney who is acting on behalf of the executor or the administrator. Now, that attorney usually has to provide a registered power of attorney proving that in the particular case they have the power to act on behalf of this particular person. In addition to this, once the document has been deposited to the registrar will sign and will also give a direction that the document is supposed to be advertised once in the daily newspaper. After advertisement is completed, what will happen is that the applicant is supposed to retain the tear sheet in order to affix that particular part of the newspaper to the particular application. Now, the oath of executor or administrator will detail a number of things. It will detail the name and address of the deceased. It will also detail the name, the address, and the occupation of the applicant. It will also detail where the deceased was domiciled at the time of his death. So if the deceased was domiciled in Canada, that will also have to be outlined in the oath of administrator. The name of the court where the grant of representation was made. In addition to this, the date that the grant of representation was made as well. The oath will also have to detail the value of the real and personal estate of the deceased person. Now, you will also have to submit all the other requisite documents. So you will also have to submit a bond, a declaration of counting of inventory, a declaration of counting of the will. You will also have to submit an affidavit of delay, and this requirement for an affidavit of delay is only applicable where the application is made 3 years after the death of the deceased. The relevant legislation in Jamaica, particularly the Civil Procedure Rule, details what is supposed to be contained in the affidavit of delay. And that particular legislation will guide persons who intend to make that particular application. Now, once the registrar is satisfied with all the relevant documents and that advertisement has taken place, then the registrar will seal the particular documents and will send it back to the Commonwealth country. Now, the grant is going to be issued in the name of the deceased person at the time of his death. So the takeaway point from this is that the resealing of grant of representation only relates to Commonwealth countries. So if you are in countries other than Commonwealth countries, then the Probates Resealing Act may not be applicable. The second takeaway point is that where the deceased was domiciled at the date of his death is very important to the application. You will also need to ensure that you submit all the relevant documents in order for the registrar in the home territory to be satisfied that the application is sufficient to seal and to send back to the Commonwealth country. Thank you for joining me today. Do not forget to like and subscribe. Goodbye.